an improved service provider with WebEx. Hopefully people are getting used to it and have been using it. A safer platform on 100 levels. So thanks for joining us again. We're just waiting for Jordy and Suzana to join in, and we're going to start our COVID webinar. Here we are, Jordy, with our WebEx.
Hi, I think I got it working.
Good, that's great. Well, Suzana's I just checked in with her, so she's just joining too, I no doubt. We want to get started. In terms of today, we want to cover off from a solicitor's perspective only, just some of the litigation issues that we need to be attuned to. So we'll talk a little bit about that, and we're going to talk a little bit about just, I would say, common mistakes in drafting that we can help with identify and also help resolve. So if to get started, and I'm not sure where Suzanne is yet, but she'll join in, no doubt. People, if we could mute your video, that helps the stream. So welcome to our seminar and on our WebEx platform. So Jordy, I guess what I'd like to start with is when we're taking will instructions and we're looking after our clients on the solicitor side, we of course need to be mindful of the dark side, that being the side that I spend a lot of my day in, and that is in Suzana, and that is of course the possible contentious issues that can arise. And are there ways to identify those issues with the clients early and often and at the solicitor's stage? You always want to create a will that works. And from my perspective, the best way for it to work is to cover off as much as you can at the creation stage. For example, when we identify in your checklist in terms of red flags, dependents are of course a red flag issue that we want to watch out for, and it can often be wrestled to the ground at the drafting stage for the benefit of your client, because you can talk through who is a dependent and maybe alert them to the expansive definition that it exists, and B, what we do about it, because zero may not be the right answer. And so otherwise you're just passing the problem on to your clients. So I guess from my perspective anyway, we'll just start with the dependent relief issue. And Suzanne, I know you've joined. The dependent relief issue really brings forward an opportunity for solicitors to provide an extra layer of support and guidance to the client. Suzanne, are you there now? All right, so maybe Jordy, you could start with your initial comments on that.
Sure. So I think the first step on the solicitor side, on the drafting side or the preparation side, is to canvass the potential dependents out there. Just briefly, the overview here is who could be a dependent. So, and that's the Succession Law Reform Act. So the things that you're testing for is first the relationship. So you're going to pay particular attention to people who would qualify as a dependent. And I'm just going to call up the Succession Law Reform Act if I can figure out how to share my screen. I'm sure I will in a moment. But so, who can qualify as a dependent? So we've got spouses. Now, spouses are broader than just married spouses. So you're going to look at common law spouses and children, grandchildren. And so those are these are people that you're going to be concerned about as far as who could be a potential dependent. And so the relationship one is the first thing. And then the second part is, is there an obligation to support this person? So, we're looking just as far as who we're looking at: spouses, children, grandchildren, siblings, and parents. And so that's the first test. Second test, of course, is the support. So is there a legal obligation to support? Well, the legal obligation to support is likely to a spouse or to certain children. And then the next question, which is the harder one, because if they have you can pretty much identify if they have a legal obligation to support. the next question, and maybe I'll defer to Suzana and Ian on the legal obligation to support, but the other one is this idea of are you providing support at the time that you're meeting with the client? Is the client providing support? And so questions about where is that person living? This is especially relevant for children, adult children, who you might not immediately consider to be a dependent, but if they're living with the client and rent-free, regardless of age, that's likely support, and that's providing support. And if they die like that, that's probably going to give rise to an obligation to provide support to them in their will.
And that's where I say, you know, we can't be afraid to ask some probing questions in terms of who's around financially. And I always sort of identify the client, say, look, who is on the payroll? And sometimes people think, well, I mean, I send a package to my cousin in Eastern Europe every month. Does that matter? And of course, that I say that as an illustration because I had a case just on that point. And a dependency was created out of that gifting. But what I'm getting at is it gives us an opportunity to really sort of dive into who's around, and it allows you to better plan. Because the other problem is, and Suzana's just joining now, is that the other problem I have is that if we don't face it and you don't put something in the will, it's the legacy you're going to leave, and that's a legacy of litigation for sure. So, Jordy, I know you're just calling up the provisions of the Act, so go ahead.
I want to see, is that working? Do you see the screen?
Yep. Oh, yeah.
This is my first time on WebEx. So here's obviously the key elements to determine if somebody's a dependent. It's the relationship, and spouse is a broad definition, not simply married, but common law as well. And parent, child, and brother or sister. And then here's the key. Was the deceased providing support or under a legal obligation to provide support immediately before his or her death? So those are the tests that we're going to throw in there in our analysis to determine whether this person, A, is a dependent now, or B, maybe a dependent down the road.
So once we've got that determination, and that section 57 definition gets us there, I often would get asked when I'm taking will instructions, so what do I do? Okay, I get it. I've got a kid who's, I've got a lifetime of dependency so far, and I don't expect them to change overnight. How much do I have to leave them? And it's the quantification of it. And Suzana, maybe you could talk to the test that ultimately, which we're trying to avoid at the solicitor stage, the test that would be applied and the calculation of how much, what components the courts look to.
Right, Ian, and that's a very objective determination. Ultimately, like the courts are going to look at a whole determination of factors, and Jordy's just pulled them up on the screen here in terms of what kinds of things get taken into account. And there's a long list of things that a judge can consider in defining what is adequate provision for the proper support of a dependent. And that's the real test. The court's looking to say, you know, given the value of the estate and given the dependency that's been created during the lifetime of the dependent, while the deceased was alive, what is now the situation for this individual? How much do they need? And you know, the real test being, you know, an adequate provision for someone. So we recognize that during lifetime, there's an income stream. And so the calculation on death, there's no longer an income stream, and it becomes very different from the family support guidelines and those kinds of considerations that get taken into consideration when someone's still alive.
So I guess, you know, and there's a case famous in our dark world called Remanion that came out of the Manitoba Court of Appeal that really set the stage on how you calculate in the sense of dependence relief for many years. And that was need. Need was the benchmark. How much does this person need? So if I'm on the solicitor stage, I'm saying, look, I got to drill this down. Like, what are we looking at? Are we giving them free rent? What's fair? And what is the need, the likely need that a court would impose on me? And second now, though, because of Cummings, Suzana, maybe you could just comment on, it's not just a needs-based test since the early 2000s. And what else is another factor in terms of the calculation?
And now, because of the Cummings decision, an Ontario Court of Appeal decision, we now also take into consideration moral obligations. So it's not simply the need that Ian mentioned, and need being determined ultimately at the time of the trial. So it's what does an individual need when someone's passed away and that claim is actually being made? How do we quantify that? And we also have to take into consideration not just those people who are making a claim against the estate, and all it takes is really one person, because there's a sheltering provision under our legislation that says that any other dependent could also be sheltered by and included in a claim for support. And so when we talk about moral claims, it's like, okay, well, are there other individuals that the deceased should have been taken into consideration? And I think for the most part, we haven't seen too many tests or too many cases test that moral dependency or that moral claim to a very high level, but it is certainly something that is taken into consideration when we want to share the pot a little bit wider than with simply the person who's making the actual claim for support.
Okay, that's great. Now, Jordy, you're just calling up the Cummings decision. I'd like you to highlight the reference I think you're taking us to, and then also next I want to talk about once we've calculated, we've got the idea of what they have, the expectations, possible expectations of the dependent. How important is it to lock down the calculation of that based on the assets? So, Jordy, finish your thought on Cummings, and then let's talk about assets and then interim clauses.
In the dependence support arena, there was always this distinction between BC and Ontario. BC had a much broader, we believed, a much broader Will Variations Act that allowed really a court to consider anybody who might be a beneficiary, and how we viewed it in Ontario was that they could basically rewrite the will. And so courts were often in Ontario saying, oh, don't worry about BC. BC talks about moral obligations and all of that. And what Cummings did was say, look, there's not a moral considerations are no less significance really in Ontario. And what the court did in this, the Court of Appeal, Ontario Court of Appeal said, look, I'm going to consider all of the moral obligations that a testator has, not only to one dependent, but to other people as well. So that's what this court really did, and considered the Tattaran case from the Supreme Court of Canada and said, look, that fits in, that consideration of, look, what is the right here? What are the moral obligations, adequate, just, and equitable in the circumstances? And that's what the court basically did. Now, that being said, and maybe you guys can comment a little bit more on how Cummings has been viewed by the Ontario courts subsequently, because I remember when it came out from the Court of Appeal, the three of us had a little bit of a party, and we celebrated it, but it hasn't had the same uptake as we might have viewed it when we said, oh, we got the Court of Appeal saying, oh, moral obligations are on. We didn't know how that was going to be interpreted, but it's been more restrictive than we maybe thought.
Yeah, and I mean, I still think it's expanded it into independent adult children being available to receive support under the Act, and that's probably as far as it's gone. Now, how much that is and the quantification is still up in the air. What do you think, Suzana?
I think also the value of the estate is a big consideration for the court, because if you've got a very large estate, then I think it's a lot easier to make these kinds of claims as opposed to a needs-based one at the time of trial. And so I think, as I said earlier, it still remains to be tested on a higher level, but in the right circumstances, we're all throwing it around, and sometimes it's assisting. But I think it's really going to hit hardest when we've got a very large estate with a number of people making claims against it.
And so that brings me to the point that when you're doing your intake is, how often, and there's a great decision, the Captain versus Captain, it's a will challenge case that Justice Letters made a comment that it really doesn't matter how much money you have when you're really rich, because you've got lots of money. And it was a good observation in a way. But the nature and extent of your assets and knowing your assets, that, you know, when clients sort of bristle on when I get into too much detail on their assets, I say, well, look, if, especially if I've got a potential claimant here being a dependent, a potential dependent, I need to give you some guidance as to how much you're going to have to leave this person in terms of parameters. I mean, it's a wild guess at some level, but to assist you, I need to get a handle on your assets, because, you know, if you have a modest estate, you could, and let's just talk about the classic support claim, and that is the surviving spouse, common law spouse. You know, you have to be able to quantify that potential claim. And Suzana, you know, when the person passes away and you've got the will in front of you, you're about to proceed with the administration. What do you do with that surviving spouse from a legal advice standpoint?
Well, certainly it's going to depend on whether or not there's a will, whether or not it makes provision for that spouse. And if it does, we want to consider basically the needs of that individual. You know, how old is the spouse? What kind of assets do they have in their own right? And what kind of liabilities and expenses, and, you know, what is their lifestyle like going forward, so that we can do some kind of a financial analysis to determine whether or not they're being sufficiently provided for under the will, if there is no will, under an intestacy. And then we are also stepping into a consideration of whether or not we might have to make a claim for an equalization under the Family Law Act. So it really is just you know, delving into the situation of that surviving spouse or partner to figure out, you know, where are they at, what is the provision that's been made for them, and if there has been no provision made for them, what kinds of opportunities or claims can be made against the estate in order to take care of that spouse for the rest of their life.
And so what about the retainer? It, depending on, of course, if the surviving spouse is the executor or not the executor, what sort of advice does the surviving spouse do you typically want to give at that moment in time?
Yeah, so if the spouse is the executor, then what I would normally recommend is that they get independent legal advice in terms of any other rights that they may have. Because if you've got a will, they're named as an executor, and they've got a duty to the beneficiaries of the estate to distribute the estate in accordance with the terms of the will. But it may be that they have other rights that they should be exploring, like a claim for equalization or a claim for support, that are different because they're personal claims that they have, as opposed to their fiduciary obligations as a named executor.
And I think, you know, I even underscored that with my clients with a double line, but like, if you're in a situation where you've got a surviving common law spouse, make sure they get advice and make sure they get it quickly. Like, it doesn't do an estate any good to leave that out there. And limitation periods run quick: 6 months from date of death for election, 6 months from probate for support claims. So from my perspective anyway, I want to tie that down with good advice, so that the surviving spouse has got the executors, whoever they are, know what the plan is with the surviving spouse, and the surviving spouse has got good advice. That brings us, Jordy, to the point of interim or no contest clauses. And I just wanted to, because we're talking about claims against an estate, I wanted to get your views on that, and Suzana, about use of these interim clauses, these no contest clauses, and especially in light of a potential dependence relief claim that exists. So, Jordy, do you want to give your initial comments when you're sitting down with the client at that stage?
Sure. The first thing I would say is, on a dependent support claim, I'm not sure an interim clause or a forfeiture clause or a no contest clause, they're all sort of the same, is going to work. So that is, in my view, not going to oust the jurisdiction of the court to provide support for a dependent. So, you know, you're going to try to look at different strategies, and I'm not sure an interim clause is going to help on a dependent support or even on an election, obviously, because that is a fundamental right that they have by law to choose between the will. And so if you're going to say, well, if you choose against the will, you're not getting anything in the will, well, that's what our legislation says anyway. So we don't have to worry about that from that point of view. But what it's going to help is if there's a question of a challenge to the will. So what it does do potentially, I guess, is take out one of the rights that a surviving spouse would have. So a surviving spouse who isn't happy with the will has, you know, a few options, but one of them is a will challenge. Well, a interim clause, a no contest clause, would oust that potentially. but then he or she still has dependent support, FLA election, constructive trust claims, other types of claims. So it is one way of just, limiting the types of claims that a surviving spouse might have.
How about you, Suzana? What are your thoughts on the enforceability and applicability? We've heard from Jordy on, but the enforceability of interim clauses.
I think it really depends on the wording of the clause itself, because it can be very broad and it can be very narrow. And, I've seen it certainly been successful in terms of avoiding litigation in situations where it's quite clear that if you make this claim, or you make, like, for instance, a claim for to challenge the actual will, so you're going to forfeit your gift. But if the individual is simply asking for a passing of accounts from the executor, for instance, does that amount to some kind of a challenge to the will? And is that caught by the wording of the interim clause? And if so, then it may require them to lose their gift. But if it doesn't, then it may be that they're still entitled to make those inquiries and not lose their gift. So it really depends on the scope of the actual provision and how it ultimately gets applied. So I know the courts are quite careful to and I've seen it go both ways. They will enforce them where they're reasonable in the court's view, and they will try to not have them apply if they're just overreaching and not fair in a sense.
Yeah, well, my dad always said about interims, he said, look, pay them enough that they're not going to want to trigger it. So put enough in the will for them to accommodate them. And secondly, as litigators, they are a good clause from a solicitor's standpoint. I got to say, having done this a long time, because every time it's in a will, you're nervous as a litigator. And so, you know what? That's not a bad thing either. If you want to sort of, so I'm actually not, I'm a bit of a big fan of them in the sense of from the solicitor's standpoint, because any good litigator has to be nervous about its impact, and its vague, the vague implementation of it. Answer that we've received is the actual, that's the truth. So if it's vague, that makes me nervous. So
just one thing about that. So if you're going to use an interim clause, you want to make sure it's one that at least gives you worry as the litigator. In other words, that it's clear that at least there's an argument, or a pretty good argument, that it's valid. There are certain requirements for an interim clause, and the key one really is that there's a consequence, a gift over, in the event that that person challenges the will. Their gift to someone else. And if it doesn't have that, if it just says, anyone who challenges my will is out, or something like that, is disqualified as a beneficiary, that might not be enough to scare you. So you want to, if you're going to include some kind of clause like that you want to get it relatively right. And I'm going to just try to pull up an example of one, if you give me a couple of minutes.
Yeah, no, take that time, because that's so true. And the public policy element of it too, Suzana, maybe you could make a comment on that, because that affects its enforceability.
Yes, of course. So if it's a condition that a court would consider somehow against public policy or morally reprehensible or inappropriate, then I think that affects whether or not it's going to be upheld or not.
Perfect.
Give me a moment here as I try to pull up an example.
Take your time as you're looking there, Jordy, because you see, I want to also just talk briefly about what role does this issue play in your intake, because it's a bit of a spicy issue, and it is maybe an uncomfortable discussion at some level.
Excuse me.
Bless you. And so, Jordy, from your standpoint, as you're looking, I also wanted to get your thoughts on how you manage this discussion at the intake stage about putting an interim clause, potentially or not, into a will.
Right. So, I mean, first, it's a question that you want to canvass, at least to have in your notes, because I always think of what could I be criticized for? And, if you don't give the client even the option to do that, no doubt the person, so take this situation where there's a potential will challenge, and I don't discuss it with the client to include with the testator to include a no contest clause. And then they challenge the will. and win or lose, I get criticized because they would say to me, "Oh, for sure, the challenger would never have gone forward if there was a no contest clause." And you say, "Yeah, well, they're not always enforceable, and it doesn't matter at that point." So, you know, it's funny. This is one, you know, whenever you're treating children differently. For example, children is the classic one where you can give rise to this no contest clause, and it's one that sort of should be triggered in your checklist if you treat children, or if the client wants to treat children differently. So that's something that, for example, you know, we have built into our software is whenever the software sees that children are being treated differently, it puts in a no contest clause to be discussed with the client, just as a heads up. So, you know, I think that's something, whether the client decides to do that or not, it's something that should be put in your notes whenever you have a client who says, you know, I'm going to give one property to one kid and another property. Like basically anytime kids are treated differently, it's something to at least be on your list.
Suzana, did you have anything else to add on the interim piece? Because we're going to move to some drafting issues now, if not.
I was just going to add that Jordy's point about just put in enough there to make the child or the individual who stands to lose pause before abruptly deciding they're going to pursue with a will challenge or what have you, because then it does give not only the solicitor or the litigation lawyer giving advice room to pause and say, okay, look, you stand to possibly forfeit this, but there's an actual consequence to it. If you just say that if anyone challenges my will, they get nothing, they lose nothing. But if they get something and yet decide to challenge it, they stand to lose that potential something. And so it just helps to keep everyone a little bit measured before they just jump into litigation unnecessarily.
I'm not sure, can you guys see this? I'm trying to pull it from one screen to another. So this is sort of, you know, if I was going along and even if I miss this, I don't remember this concept or I don't consider it. You know, if I've treated the kids differently in the client's instructions, then this is a sample forfeiture clause that just basically pre-populates, and it's basically makes the gifts conditional on signing a release within, you know, and the default is 3 months, but you got to consider where that is, and then it considers as well, should that also exclude the gift over beneficiaries of that gift and things like that. So just as a sort of you know, a heads up that this is something to be discussed with the client, and again, there's so many things that we have to discuss with the client. It's, you know, and to properly discharge. But anytime you've got this red flag of children being treated differently, you know, it's a question to ask whether you put it in. It's a very small percentage of wills where you'd have a forfeiture clause, but it's still something to, because if it ever happens and you don't have any notes that you may have mentioned it, but if you don't have any notes on that or any evidence that you did and that the client decided not to do that, it's a concern.
Okay, thanks so much. All right, so I want to shift the discussion now to really address, and this won't be finished by any means today, but talking about some common mistakes in drafting wills and working through some of those issues. You know, for example, clauses that are missing or problematic, or clerical and typographical error mistakes, errors involving codicils, those kinds of things that we encounter in our practice, our drafting practice. So why don't we start with clauses that are missing or problematic? And maybe, Jordy, we can start with that from your perspective, because there's probably 5 or 6 that I sort of noodle about and worry that, you know, because we've talked about the interim clause being a bit of an outlier and not a big volume of our practice, but let's start with that. Do you have any thoughts, and we can talk through some of those considerations?
Yeah, you know, I'm going to leave aside the, you know, remember to put in a residue clause, because those ones are, you know, if you're forgetting the residue clause, then we should talk. But you know, I think that there's a few that sort of stick out, and one of them is this idea of successor trustees. So we often put in there that we can, let me just pull this up and give me one moment here. Where is share content? Here it is. Here's a clause that often, especially if you're using an older precedent, might not be there. So you've got a situation where you've got trusts for younger beneficiaries, and they may be quite remote beneficiaries, because this is sort of a general clause. It says if anybody inherits under the age of X, and it appoints the executor as the trustee of that money. Well, the executor might not be the best person to be the trustee for, let's say, a grandchild or a niece or nephew. And so the ability to allow the trustee to appoint a successor trustee is important. And so this is sort of pretty standard clauses from each state that talks about the ability to transfer the trust, the capital of the trust, to a successor trustee. The older school clauses never said this. They had a clause that said basically you can make any payment to the parent or guardian. And it stopped there. And people, I think lawyers always assumed that, well, that meant you could transfer the whole capital of a trust to the parent or guardian, and you'd wipe your hands and be done with it. But the case law says that wasn't the case. That's not what that clause meant. And so what you needed to do was have specific language about appointing, basically transferring to somebody who shall become the successor trustee. So that's something to check your precedents on to see, is my wording correct? Does it talk about a successor trustee, or does it merely say make any payment to a parent or guardian, which is not, based on a case called Headley and Grant, sufficient to do what we thought it was, which was just, here's the whole capital, take over.
And you've got Children's Law Reform Act problems too, if you're not careful with anything excess of $10,000. Yeah, it's funny, that clause and putting it into a will is such a great pour over from inter vivos trust drafting. You see that all the time in an inter vivos trust, not all the time, but many times you'll see it in inter vivos trust. You'll have that kind of language, but you don't see it in wills. And I've never totally understood that. And the Headley case really brought it forward. That's a great observation. All right. So, and now in terms of that, sorry, I'm going to let you. I won't. You have other clauses that that could be missing or problematic that you'd like to discuss, and I'll go through mine after.
Yeah. So I'm just sort of pulling some that I thought maybe we would just talk about, and I'm not even sure that it's a major issue, but for example, the revocation clauses. There's a lot of debate about, not a lot of debate. There's a modest amount of debate about what should, do you need to refer to codicils and other testamentary dispositions, or should you, or what kind of restrictions you put in? And so, I think that some of the older precedents might just say, for example, would exclude this provision, which is, not crucial, but there are cases out there that talk about a general revocation clause that would revoke beneficiary designations. So if you're, that's a provision in a will that I would want to, unless I'm intending to revoke all prior beneficiary designations, and I wouldn't rely on this to do that. I think it's a good idea to exclude that from your revocation clause because of these outlier cases. And so many of our clauses and amendments to, our wills are updated all the time, and they're based on these outlier cases that change what we thought was right, and so we have to sort of adapt and change to those kinds of cases.
Yeah, and the designation issue, of course, Suzana, you and I see a ton of it, problematic issues on the litigation side. A clause like this is such a clean way of dealing with it. Did you have any thoughts on designation issues, Suzana?
Not so much on the designation issues, but the fact that I've seen many instances where the revocation clause becomes a major issue because someone has a foreign will that they may have just forgot about or didn't mention on the intake side of doing their Ontario will. And so that's something that I'm sure is part of your checklist, Jordy, that you want to make sure that we're looking into, are there any other foreign testamentary documents that would be affected? and how do we then deal with it? And that clause, the revocation clause, also really important in the dual or more than two will situation, where you want to make sure that you're using the right language there. And I think you must have precedence for that as well, Jody.
Yeah, absolutely. It's, it's a checklist for sure. Whenever you see that there's foreign property that the client has, that you want to for sure check that and say, okay, how are we going to deal with that? Foreign property and is an issue, and Suzana, you've made that point very well, because that's what gets us into trouble. You know, when people own property, you know, in Spain and Mexico and China and you know, all over, and how do we deal with that? And it, you know, every file seems to have a problem, and that's the big one often. And so, you know, our advice generally is to say, you probably, especially land, you know, my default is to say, look, the best advice I can give you is go with a foreign, you know, go do a will for that in that jurisdiction for that land, because land, you know, is governed by the law of the land. And so I can't give an opinion on whether my will is going to cover Spanish property, land, and because many jurisdictions have forced heirship with respect to land. So in that case, you know, if I said to them, oh yeah, don't worry, your will's going to cover, you know, notwithstanding that our will says all property wheresoever situate, you know, typically it governs all. You know, it doesn't apply to land in a foreign jurisdiction unless that jurisdiction recognizes our wills. And so, you know, the first recommendation is to go get a will done in that jurisdiction. And if they haven't done that yet, then what you want to, of course, caution them is when you speak to this lawyer in Spain, make sure you tell them that you're not intending to revoke this will. Right, so we could screw up by revoking foreign wills, but they can screw up by revoking Canadian wills. And so, you know, that's something that was, you know, I would prefer to warn the client of something and put that in writing, that if you do go and sign a foreign will, as I've recommended, that you know, remind that your counsel there not to revoke this prior will. Would you be liable if you didn't do that? I hope not. You'd hope that the other lawyer would be the one who was checking about that, but it's still not a bad idea to remind the clients for foreign property. So I think that's really an important point when we talk about things that are missing in our wills. Sometimes, you know, something as fundamental as, you know, prior wills that we want to keep, or other wills in foreign jurisdictions, really important.
And maybe Suzana too, like a common, I like your Spain example, but a common planning question coming up with Ontario State certainly is Florida property. Do you have any sort of different or anything you would add when you're faced with someone who has some Florida property in the planning stage?
Well, yeah, I mean, I'd use the same line, that I don't give foreign advice, and you'd be best to consult Florida counsel on it. And that, you know, some people, first of all, there's other planning that you might want to do rather than just owning it in your own name. So I would probably recommend, depending on the size of the estate and other things, recommend talking to a cross-border specialist. But I would say, you know, your best bet is always to have, most of the time, to have a will for that jurisdiction in Florida. I can say from my experience, though, Ontario wills have been used to convey Florida property. But that's just my anecdotal advice or anecdotal experience. So that's what I would do. I wouldn't, you know, maybe I'd be less concerned, because I do know I have a little experience about how it practically works in Florida.
Well, that's great. Just because I'm getting used to this WebEx program, there was a great question in the chat line, and I can't call it up again, so I'll try to rephrase it.
Wet signs foreign documents?
Go ahead, if you can get it called up. No, it's about successor trustees.
Oh, okay, go ahead. No, I don't have that one. Yeah, sorry.
Yeah, I don't know why I don't have it. I had it and then I've lost it. But anyway, the scenario, of course, where what do we do with a situation where a successor trustee has passed away in the middle of a administration, sorry, trustees passed away in the middle of an administration, and that there's still work to be done, but there's no successor trustee appointed under the will. Jordy, what do we do there?
So you'd be under the Trustee Act. And so there's a distinction between executors and trustees. If you give me a second, I'll try to call that up. But you may be into a court application. And that's, you know, in short form, that's likely what you're going to need, because you're going to need some evidence of the successor trustee having authorities, especially if you're dealing with trust assets. So that's likely what you're going to do if you don't have any other provision in there, and assuming you're talking about the sole remaining trustee. So,
well, that's great.
Another just question. A couple, maybe just to talk about that, but there might be a situation where if the trustee has appointed a successor in their will, there is a provision for that. Depending on, you know, that's something to check as well. And there is a sort of holdover provision that says that the executors of the sole trustee can do it until there's an appointment of a new trustee. So there are some provisions. If you look at sections 3 and 4 of the Trustee Act, that's and I just can't call that up right now, but that's sort of where you're going to go to look at that.
Okay, thank you. Bit of a change of the topic, but one that's a bit of a worry. I don't know how relatively speaking, all the jurisdictions are reacting to these virtually sworn affidavits. So the probate applications virtually sworn, can we speak to the court's acceptance of them? The question is, they've been receiving conflicting comments, and in fact, Bev Chapin's told us that Toronto's been giving some won't accept virtually sworn applications. So what is your experience on that? And Jordy, this is a bit worrisome, isn't it? That it doesn't make a lot of sense to me that the court's not accepting them.
Yeah, I just actually got a note from our group. I think Barry Corbin was the one who sent it around, that said that now somebody has spoken to the courts and said, look, you got to accept these now. And so I'm told but I don't have personal experience, but that's what I've heard. They are now accepting them.
Oh, good. All right. Well, we solved that problem. Okay. So now, Jordy, got another chat here. Let me see. Yes. This has been verified on the chat line as well. So that's good. I love it. This webinar solves problems as well as it can. Okay, Jordy.
Just 1 second. I have a question that came to me. So I just want to address it. I'm just reading it. Has anyone been able to clarify if we still have to wet sign sworn documents, or can both the signer and the commissioner now electronically sign? Do you know the answer to that? I think you have to still wet sign, if that's my understanding.
No, yeah, I don't think it's changed. You're still wet sign. Although it was good, there was a sort of a town hall webinar yesterday I watched that the Attorney General spoke at, and he specifically referenced the fact that he is anxious to put in some longer term resolutions to the will process. And he particularly mentioned one which I thought was interesting, and I've heard this from him before, is his big bugaboo is probate, and he thinks that we should be able to come up with a way to have it much more electronically and digitized, and that we should be able to get to the point like they are with real estate in terms of verifying probate on a much more streamlined basis. And he said that's a big bugaboo for him and a priority when we come out of COVID. So I thought that was interesting, and we'll see where that goes. We're going to try to put together a team of lawyers that are going to start to approach the minister as well. I know the OBA is working on it as well. We're going to come out of this with some tangible changes in every respect. Okay, so we've got probably another 5 minutes. We wanted to just talk about Jordy, and maybe I'll just stop there. I got another question here, but while I'm looking at it, do you have another clause that you'd like to just raise before we, in the last 5 minutes here, in that regard?
Right. So, excuse me. I just wanted to, basic one more clause that I want to talk about, and this is and let me see if I can share here. Can you see? Can you see that? There's a payment of double legacies. Can you see that?
Yes.
Okay, good. So this is a situation where you've got clauses in your will. It's the double legacy problem where both spouses have the same legacy in their will, and if they die close to one another or at the same time, then you're going to end up having to pay these same amounts twice under the two wills. And so this is a clause that one should consider including if you've got matching gifts, legacies. And so what this basically says is, look, if we die at a time where the same legacy would be paid under both wills, then I don't want it paid under both wills. If necessary, pay it half for mine and half for my spouse's, or adjust it otherwise. And so that's a clause that we can easily forget if we're not cognizant of the fact that we have matching clauses or matching gifts. And again, as you know, this is where, again, technology can help because it knows what's in both wills and says, oh, we got matching initial gifts, we better put this clause in.
No, that's an important one. And you get balled up a little bit when you've got grandchildren gifts and so on, and it's important to track that, or else it ends up double gifting. All right, we're having a good discussion on the chat line about timing for probates. It's all over the map. It looks like Toronto's maybe starting to look at ones that were filed in December, and that's the kind of backlog that they're dealing with, and that Newmarket has been issuing applications really quickly. So that's interesting, and that's all good, helpful feedback in terms of what's going on in probates. That's obviously a vital part of the timing for clients, and in fact, that was exactly the point that Justice and the Attorney General mentioned, is that the timing for probate, shrinking it, is important both for clients and the economic requirement that we get liquidity going on assets as fast as we can, and the probate is needed for some of those assets. All right, Suzana, did you have anything else to say about the clauses that are missing or problematic? And we've got lots more to discuss, and next week we'll see any developments and also continue to talk about common mistakes in drafting wills.
Actually, yeah, I just wanted to mention one of my favorite clauses as a litigator is the gift over clause. And when you've got a trust that says, staggers out an entitlement to someone being entitled at certain stages, and providing that if they don't survive, what happens or what doesn't happen. And I think, we get so bogged down in the actual drafting that sometimes we forget to follow the logic tree all the way to its conclusion. And so if you have a trust that does not have a gift over at the end of whatever the provision it may be, then there's the possibility that the beneficiaries of that trust, if they're of age and all capable, can actually collapse that trust by virtue of the ancient principle of Saunders and Voce. And so it's something that I certainly, every time I'm reviewing a will, I just want to make sure that I've looked to make sure that it is in fact a valid trust, that there is a gift over, that there is a consequence if someone doesn't survive, because otherwise it just does open it up to litigation and another way to defeat ultimately testamentary intention.
Oh, that's a great point. All right. Well, I think that sort of covers off the areas that we wanted to track this week. Jordy, do you have anything else before we close off?
No, that's I don't have anything else.
Okay, well, thanks everyone for joining us, and we'll be back next Friday, the same time and the same high-tech WebEx platform. So thank you so much. Thanks everyone. Be safe.
Thank you. Take care.
Bye now.